You're listening to the Roofing Success Podcast, a show created to inspire roofing contractors to achieve optimal success in their roofing businesses. I'm the host, Jim Moline, the co-author of the book, Internet Marketing for Roofing Contractors, How to Triple Your Sales and Turn Your Roofing Website into an Online Lead Generation Machine. I'm also the co-founder of Roofer Marketers, the digital marketing agency for the roofing industry. On each episode, I'll be sitting down with industry leaders to talk about their processes, the lessons they've learned, and how to find success in roofing. Hey, welcome to another episode of the Roofing Success Podcast. As always, please share, please comment, please subscribe wherever you're listening, wherever you're watching. That helps with the algorithm. So to get our content out to more and more people. Today we have a special episode, special urgent announcement, at least for you Florida people, right? At least for the contractors in Florida. But very, very excited today to speak through all of the changes that are going on in Florida that will be going into effect July 1st for all of the contractors down there, the implications of it, and kind of what that looks like on a nationwide basis for everyone. And so today we're speaking with Winston Taitt from Taitt Law, Sharon Freeman Sharon Freeman from Taitt Law, and the one and only Patrick Carr, who's been really digging in and following this along the way. So guys, Winston, if you want to introduce yourself and kind of introduce Taitt Law to and what you guys specialize in over there, and what you've been doing in relation to SB 76.
Sure, 100%. We're a property damage firm based in downtown Orlando. We service the entire state of Florida. 90% of our practice is property damage. We also do construction litigation and appeals. My personal background is I've been practicing in Orlando since 2007. And beginning in 2010, I've done exclusively property damage work, all on the consumer side. So we represent homeowners, roofers, contractors, all against insurance companies. We only work consumer side and across the entire state. And certainly, so we started by, initially going up to Tallahassee and giving public input in the Senate testimony in opposition to the bill. So part of it was just a grassroots effort, manpower going up. Patrick Carr went up with myself. We both went up several times to actually try to influence the legislature to not do any reform. So the current bill that we have is somewhat of a compromise reform. So we'd like to think that some of our efforts weren't in vain. So the first thing we did was to try to, prevent this bill from going into effect. Once it was signed by the governor, what we did is we kind of reviewed it thoroughly with our team of attorneys, and we kind of created a roadmap for roofers, because this could be very daunting for roofers, right? You hear about a new law, particularly because the law that we have is drastically different than the law that was originally proposed. There's a lot of misinformation out there. There's a lot of people who believe that what was passed and what goes into effect on July 1st is what was being discussed in February. They're night and day. And so what we've done over the past 2 months is just meet with roofers live or by Zoom and just let them know, hey, this is not the bill that was originally proposed. Here's what it is. It's an unknown bill, but here's the roadmap for your business to continue to be successful. Our take on it is that this is certainly reform, and this is important and serious reform that roofers have to pay attention to, but it's not devastating. So it's not what it was originally, proposed.
Yeah. So let's speak to that a little bit. Where did this come from, right? Where did it come from, and what prompted this legislation, do you think? And what was that original the original legislation that most of the misconception right now is kind of being caused by?
Can I jump in? Okay.
Yeah, absolutely.
This started about 5 months ago with a legislative session, Jim. And at that time, what Winston was just referring to is the original bill for Senate Bill 76. And what that did is it had an ACD policy in it, which basically meant that every roof over 10 years old in the state of Florida in some way would revert to an ACD policy. That means depreciation would have to be covered by the homeowner. I think that we can all see what would happen if a hurricane rolled through the state. Individuals would be responsible for their hurricane deductible, and then on top of that would be responsible for depreciation. It would be devastating to Florida homeowners, especially following a pandemic where individuals don't have $10,000 sitting around in a bank. It would lead to predatory lending. You can imagine the kind of interest rates that people would be charged because they would need that roof on their home. So, myself, Winston, Sharon, others, we're fighting against that, trying to show people there's a realistic human side to this if you let SB 76 pass in its original form. That's how we started to get things changing. Now, the way that it works in the state of Florida is that you have a Senate and a House bill. And so both these bills molded their way through committee. And when they finally made it to the floor, a lot of individuals kind of felt like this thing was going to die. However, though, we know that big insurance has a lot of money. And so they wanted to get something done. They couldn't let it be nothing on the table. State Farm wasn't going to let that happen. And so what they came up with, as Winston said, is this compromise bill. And there's only a couple sections that have to do with the roofing contractors. But I think that there was a misconception because in the beginning it was so awful that the fear was there for roofing contractors. And that fear still remains inside because of what they were told for 3 months leading up to this thing. So that's what I'm hoping we can do here today over the next few minutes is try to put some of that fear to rest and also explain exactly what we have right now. And then in the future, try to shed some light on what we can expect in the next legislative session.
Perfect. So Sharon, I know you guys have laid out a roadmap for this to help contractors really get a grasp on it and make sure that they're in compliance and doing the right things for their businesses. You want to speak to that a little bit?
Yeah, absolutely. So like Winston was saying, SB 76 is a 44-page bill that's now been signed by Governor DeSantis and will be going into effect on July 1st. Within that 44 pages, 14 statute sections have either been added or changed in some way. And really, those 14 sections address 5 main points, and that's solicitation for roof claims, deadlines for submitting property insurance claims, as well as things on the back end for us attorneys, like required pre-suit notice, consolidation of lawsuits, and attorneys' fees and costs. And so what Winston and I have put together is kind of just a roadmap that primarily addresses the things that are most important to the roofers, the contractors, and the PAs that we work with, which involve the solicitation, as well as, to an extent, the deadlines for submitting those claims.
So let's start with the solicitation. We own a marketing agency, and boy, were people worried about that, right? No more door knocking in Florida. Like, do not knock a door in Florida. Don't say anything about insurance in Florida. We gotta so let's talk about what was maybe proposed in the beginning and what is really the true actual effects of the legislation.
Yeah, absolutely. So first and foremost, SB 76 outlines prohibited activities. It doesn't tell us what we can do. It only tells us what we cannot do. So we think of it like putting up a fence. However, our contractors want to operate within that space is up to them. That's a business decision. But what we like to do is just guide as to what the prohibitions are. And you touched on a really interesting point. So a lot of people think that door knocking in Florida is dead, and that's just not the case. That would have been the case had SB 76 passed as it was originally proposed. But now SB 76 doesn't get rid of solicitation. It simply limits what contractors and PAs can advertise and how. And so there are a bunch of prohibited activities in terms of solicitation. But what it boils down to is that contractors and PAs in Florida cannot encourage, instruct, or induce a consumer to contact them for the purpose of making an insurance claim. And so that doesn't mean that you cannot advertise. It doesn't mean that you cannot door knock. It just means that you cannot advertise or door knock for the purpose of filing a claim. And so what I like to tell my roofers is you guys need to focus on selling roofs, not selling insurance claims. Advertisements can't be for the purpose of making an insurance claim, and that could be anything from the flyers that you see, door hangers, yard signs. I've seen truck wraps, websites, what you're putting out on Instagram, anything like that cannot advertise or instruct a consumer to file an insurance claim.
And this can include things like Instagram posts. So
Right.
one of the things is, and I have this in front of me on my phone, and I screenshot this from yesterday, which is just 2 days before the law goes into effect. And it says, let us know, free roof inspection. Well, that seems like that's not an enticement for insurance claim. I think that's fine. No obligation. Well, that's fine. No money due up front. I think that may be okay. But then it gets into insurance may cover your roof, right? So now what you have is something that I screenshotted it. So if I can screenshot it, the Department of Financial Services can screenshot it. Department of Business and Professional Regulation can screenshot it. And it literally says insurance may cover your roof. Now, is that prohibited under the new law? Could that be seen as an enticement or encouragement to have someone file this insurance claim? Absolutely. But more importantly, it's there in writing forever. So when you start dealing with, there's gray areas and non-gray areas, certainly in your written advertisement, if you can induce an insurance claim, writing on your advertisement, free roof inspection, insurance may pay for it, could certainly be, there's a lot of questions. What is encouraged? What is entice? What does induce mean? But saying free roof inspection, your insurance will may cover this. I think that is part of what was meant to be regulated out. And if this ad ran 2 days later, I think there's the potential for that company to be, potentially subjected to at least an investigation and a probable cause determination. So when you look at it and you take these things chronologically, you're starting with advertising and soliciting. Certainly your written materials should not entice an insurance claim. Like that's a simple first step, right? We can work our way through, Patrick likes to think of this as a chronology, right? Let's walk through the entire process. Well, before you even are at that door, if you have an Instagram post or if you have a door hanger that is enticing people to put in an insurance claim, that would be violative of the statute. There was another ad that I got screenshotted that says claim consultation, insurance claim problems, we can help. I mean, once again, you're looking at things that are directly, the language says you can encourage or entice someone to contact you for the purposes of an insurance claim. This type of language that I just screenshotted yesterday, again, in 3 days, will likely be squarely within the prohibition of this new statute. So as you're looking at all of the potentialities of this bill, let's start with the most basic. Don't entice people to contact you to file insurance claims. It's prohibited under the statute.
Yep. And similarly,
For 1 second, because that's where I was really I was really confused on that, right? That enticement and things like that. And we'd spoken the other day, and it's really pre-inspection language and post-inspection language. And I want to make sure that you guys understand this very clearly, that contractors out there understand this very, very clearly, that there is a line, because I was confused personally as could you encourage, I thought maybe there was the language said that you can't tell that homeowner to even contact their agent post-inspection. But that's not what you were, what you derived from this, correct, Winston or Sharon?
Yeah. Sharon.
Yeah, and so really what SB 76 does is it sets up a framework for timing. So the one thing that SB 76 does expressly allow is once contractors are permitted to recommend to the homeowners that they contact their insurer to see if proposed repairs are covered under their policy. And so that language in and of itself kind of sets up a chronology for us. So it assumes that you have proposed repairs, which assumes that you have an explanation of damages. And so SB 76 almost sets up a timeline for contractors to provide a transparent method or a transparent process for these homeowners. So you would provide a free inspection. SB 76 prohibits contractors from offering anything of value to homeowners for getting up on their roof to inspect it. So timing wise, you'd have a free inspection of the roof. The contractor would then come down, talk to the homeowner, explain the damages that they found, explain the proposed repairs. You would need a full re-roof because we have to comply with the building code, or I think that you only need a repair because it's only in one spot. They would then provide an estimate. Here's what we would need to do in order to make your roof whole again to protect your investment. And then at that point, the contractor can say, here are the damages, here's our proposed repairs. We highly recommend that you contact your insurance company to see if these repairs are covered under your insurance. And so a lot of people think that SB 76 prohibits any sort of advertising. It's just not true. They think that it prohibits you from talking about insurance at all. That's not true. What it does is it sets up a timeline and a framework so that homeowners are fully informed by the time that they're signing those contracts.
So that's the other part, is what we were hearing a lot about is estimate.
Yes.
Right? That's a line, that's a milestone in the process, right? Especially in the new process, where before you could say you have damage, here's your pictures, call your insurance agent.
Yes. Yeah. And so now one of the largest changes, and one of the things that we're finding are going to be most impactful for our roofers is the SB 76 requires that contractors provide an insured with an agreement authorizing repairs with an itemized estimate. You cannot get that authorization without providing a detailed, itemized, and good faith estimate. And SB 76 says that it's okay if your final invoice differs from the initial estimate, as long as that initial estimate was made in good faith. And again, this is just a measure for transparency. Show the homeowner what it is that needs to be done, how much that's going to cost, and then let them determine if they want to move forward with your company at that point.
And I'm not sure what the scope of roofers that you deal with, but there are some roofers who don't even write their own estimates, right? There are some roofers who go out, sign homeowners up, and they have an estimating services, or they have an in-house estimator. And so for those type of roofing companies, this is going to be a big component of the bill, because if you have an agreement authorizing repairs, you have to contemporaneously provide a good faith, detailed, and itemized estimate. So if your prior business model has been, hey, we're going to take what the insurance company paid, well, that just can't fly, because this is clearly articulated in the law that there has to be the contemporaneous agreement authorizing repairs has to come with an estimate at the same time. And so this is a big deal. And I think, you have obviously the written solicitation materials, but this is going to be the next big thing that you have to consider is, how am I going to generate a good faith, detailed, and itemized estimate of services and materials on the spot, right? So are you going to use a software? Are you going to go back to the old school carbon copy, 10 line items, and it's a 20 square roof at 550 a square, and so the price is 11,000? That's going to be a business decision for roofers, but I can bet you that Patrick Carr will attest to you, the very first question that some of these adjusters are going to ask when they come out is, were you provided with an estimate at the same time you signed the contract? If not, it's very much like that advertisement. It's right there. You've made the case for the Department of Financial Services. You violated the statute on its face by not providing it. I would either send them the email of it so that you have proof to protect yourself, have a signature that they have that estimate, or have a carbon copy with that signature. This is one of the big requirements of the law. And so this is one of the things that I think your roofers and your audience has to give some thought to, is how do we generate this estimate on the spot? Because certainly we don't want to do the hard work of getting in the house, getting on the roof, going through the process, and then leaving and saying, hey, we'll get you an exactment in 3 days.
Yeah. And I think that's going to be a tough one for some contractors out there, getting a detailed estimate to a homeowner, especially salespeople in the field when they're out canvassing and doing those things. Being able to generate that in a timely manner is going to be, that's going to set companies apart by being able to do that. So technology is probably going to be a solution there. I don't know what the solution would be offhand, but boy, technology is definitely going to be a solution in that regard.
Jim, what I would say is this: as your sales reps go out there, because I know a lot of sales reps follow you, they're going to be nervous because they're going to be wondering, do I need to change my pitch? Am I going to say the wrong thing here? Am I going to get myself in trouble or my company? My advice to those individuals is to fall back on the law as a sales tool. So if you don't know what to say, fall back on Senate Bill 76 and say, Mr. and Ms. Homeowner, I want to make sure I'm erring on the side of caution because a new bill was just passed. And this is what the bill says. It says that I have to provide you with a good faith estimate. And the reason for that is because you pay your insurance premiums and your insurance company wants to know what the possibility is that they're going to have to pay. And it says here, I can't induce you or give you kind of an incentive to file a claim. And I'm going to make you initial that, Mr. and Ms. Homeowner. And here's the reason why, because I do things by the letter of the law. If you're not sure, and as a rep, revert back to the law, make yourself the expert in the room on that, put your homeowner's mind at ease that you're doing things the right way. And it gives you an opportunity at the same time to coach your homeowner. So now we've been able to go ahead and establish you. You're selling the job. You follow within the guidelines of insurance, and you're the expert in the room on it. Fall back on the law right now when you don't know what to do.
Definitely. And that's, from going through, previous law changes in other states with our clients, like in Texas, a couple of years ago, a lot of the contractors we work with, their salespeople had the law on the clipboard.
Yes.
Right. And when that homeowner said, hey, can you, the last guy told me he was going to eat my deductible. You go, here's the law, Mr. and Mrs. Homeowner. Let me show you why that's illegal and insurance fraud. So, making yourself an authority, making yourself trustworthy, that adds a level of trust. And I would guess that there is no company out there that wants the fines behind whatever the penalties are behind this new legislation.
There's not, but I'll make this other point regarding the sales reps. I think very important, Jim. The insurance carriers are not playing this by the book. Whether it be American Integrity, Frontline, I've been reading their emails. I've been sent to me. They are telling their homeowners via voicemail that there is door knocking is dead. No one can solicit you. They cannot come to your door. So reps out there need to be prepared for that to be the opener that they're going to have to deal with. Now, I would challenge everybody to take it as a positive, to be able to now turn that and tell homeowners the correct way of looking at things. If insurance carriers are going to go low on things, and take the high road here, and let's explain the law to homeowners in the correct way. It puts you again in that expert status as the authority on the law itself. While the insurance companies take the low road right here, we'll do things the right way, and I think you'll sell more roofs in doing it.
Definitely. So continuing down the roadmap, how do we, what's next for these contractors?
Sure. So I know that a lot of contractors don't do this already, but SB 76 specifically prohibits contractors from interpreting policies, making coverage determinations, advising homeowners what may or may not be covered under their policy. And again, we just tell everyone, revert back to that language. SB 76 has given you language. We strongly recommend that you reach out to your insurer and see if these proposed repairs are covered under your insurance policy. And so when you run into those issues, it's always good to just fall back on what the law specifically tells you that you can say. Additionally, SB 76 says that a contractor may not execute a contract with a homeowner without including a notice that the contractor may not engage in certain prohibited activities. That would be the offering anything of value in exchange for getting up on the roof or filing a claim. And so the easiest way to do that is to actually take the language from the statute, and that's section 489, 147, 2B, and just popping it straight into your contract. If that notice is not included in the contract, homeowners have 10 days to void it. And so I don't know about you, but 10 days is a long time to think about a contract that's worth potentially tens of thousands of dollars. So it's always, it would behoove the contractors to just make sure that that language is put in there.
And just copy it over word for word. You're saying,
yep.
Just copy it over word for word, maybe put an initial box by it or something, maybe, like, just to emphasize, like, hey, I did this. We did this. We're following the law.
Yeah. And you can just put in, Florida statute prohibits us from, and then just copy and paste that in and that should be sufficient under the law.
And I think of this as an opportunity, right? So do we use insurance as a crutch? Do we say free roof just to sell roof? Probably so, right? Because it's enticing and people like things that are free. And now that a lot of that is prohibited on the front end. So another thing that you can do that's not in the statute is talk more about the service you provide, right? Say, hey, the carrier is going to do their job. They may do it well, they may do it poorly. We've looked at this roof. We can go over our bid, we can go over our contract, and we don't know what the insurance is going to do. But here's what I can tell you we are going to do. We're licensed, we're bonded, we have referrals. Here's the type of shingles we offer. Here's the warranty we offer. Here's how we're compliant with the law. Here's how we're going to make sure that you're HOA compliant. You know, our subcontractors aren't going to leave pizza boxes and Modelo's around your yard, right? So now you're kind of shifting a little bit away and saying you're creating a team, right? Now this homeowner can, and this has nothing to do with the bill, but let's think about it. Now this homeowner feels like you're their ally, you're their teammate, right? And you're waiting to see what the carrier is going to do. And if the carrier does the right thing, then the team's won. If they haven't, then there's ways of escalating it after the carrier doesn't do the right thing. So as much as is taken away from this bill, I think it gives people an opportunity to create that, that feeling. How do people sell when there's no insurance involved, right? They talk about their product. Patrick was telling me in some states, they leave binders. They leave binders with a picture of, hey, here's how your roof is going to look, right? That's going to go a longer way in this post SB 76 world than anything else. And I think that, I think we shouldn't overlook the power of just old fashioned making someone feel special and looking at a roof and saying, this is the people I want because they provided me with their insurance. They provided me with their workers' comp. They provided me with shingle samples. They showed me, they've given me that good feeling because it is a good feeling. I got my roof put on after Irma. It was a great feeling. I loved walking home and looking at my new roof, right? Give people that feeling. And I think that'll go a long way to creating that team such that if insurance does make the wrong, determination, that they trust you in what the next steps are on pursuing that claim, right?
So it essentially, it's going from the traditional storm damage restoration pitch of, your neighbor's house was bought by the insurance company. You could get a new roof for your deductible, also to a more retail style pitch. It's not, So
with an insurance twist, right? Because they're allowed,
where insurance could potentially pay for your roof after we give you this full, complete, detailed estimate.
Yes.
And then, are any other things that you should add to your contract other than that, just that one, that copy of that one specific piece of language?
So based on the statute itself, that's the only requirement under the statute, right? So now the question is, what else should you add? Since you have to have a detailed good faith estimate, do you consider now that being a sheet on your estimate where you list underlayment, drip edge, ridge vents, ice and water shield, demo, whatever it is? Do you now just have, you were talking about a technology-based solution, but there's another way of looking at it as an old school-based solution, which is the third page of the contract is simply a check mark price to all the detailed and itemized services and materials and labors that you're going to be providing. So that's something to consider. So you have the language from 2B, you have the potential that you're going to add in your estimate on the contract. And some people, and this is a business decision, some roofers are going out there and saying, hey, we're going to have them sign off that we didn't solicit them, that we did provide an estimate, that we didn't give them anything of value. And these things I like to think of as that doesn't mean that you didn't do those things. That doesn't make you foolproof. That doesn't protect you from an administrative hearing. But what it does do is I think of it as a certificate of satisfaction, right? At the end, when you put on a new roof and that homeowner's looking up and they're gleaming and they sign, yeah, they did everything perfect. 6 weeks down the line, when they say, hey, we have a problem with this, we have a problem with that, you get to remind them, hey, do you remember you had the opportunity to inspect, you had the opportunity to look around your yard for nails, you thought everything was fine at that point in time. And that little add-on kind of has the same impact of a certificate of satisfaction. It's just a piece of evidence that you didn't do these things And I, that's something that you can also consider. So the language, potentially consider the mandatory language you have to add, potentially considering the estimate because it has to be on there, and potentially some sort of add-on language that we fully comply with the statute.
Nice. And so you had said, so that the process doesn't really change post-inspection, post-estimate. You had mentioned, what if the insurance comes back with the wrong decision? And, how do you, where do you take that from there? It's all the same process from there, correct? Nothing changes. You're going to appraisal, whatever you're doing, you're just continuing the process the normal insurance claims process.
I love the way you put that. And the way I put it is not prohibited and not in the statute. So the statute, those are things that are unaddressed, right? So that's the best possible answer. There's a lot that, there's a ton of questions. And these are all questions that I'll tell you that I don't have the answer to, but I can tell you are not addressed in the statute. Can I sit down with the homeowner? Can I be at the inspection? Can I, to what level can I have some involvement post-claim? My answer to that and our firm's answer is simply, let's look at the law. The law doesn't address those things. We can't, if we take SB 76, we've thoroughly gone over that with you. We also have SB 1598, which is another alleged consumer protection bill that was signed on June 16th. What I like about that language is that it again tells you, you can take your estimate and you can go line by line and say, hey, the building code requires this. Here's how your roofing is a full system, and here's how we're going to restore your full roofing system. There's a lot of potential to explain how you're going to help that homeowner in an insurance neutral way that's allowed under SB 76 and 1598. But all of those questions regarding, can I sit down there with them? Bill is brand new, it doesn't address it. I don't know that we can tell you yes or no, because you may get a zealous homeowner, you may get a zealous adjuster, and then they come back and say, hey, you guys told us to do this, so we stay away from that.
Yeah, that's good advice. That's the thing about new legislation. It's, there's some things like we were talking about, Winston, that are cut and dry, they're crystal clear, but then there are other things that are a little bit in the gray area that weren't fully addressed in the legislation, but addressed enough to where you got to make some decisions on the, for your business, for sure.
It is a business decision, and each one of these questions, each one of these ambiguities, it's going to be a lawsuit, right? And it can take years to resolve. And so that's why, with new legislation like this, it's always better to try to stick as close as possible to the letter of the law, what it does allow, and not be the guy that they're making the example of.
Perfect. So next on the roadmap.
Yeah, so we also like to just inform, our roofers about what may happen if you violate the statute. Because a lot of people are really concerned. What does this mean? Is it in a court of law? Is this an administrative court? Is this just a fine? What is it? And without going into too much detail, the statute says that each violation is $10,000 per occurrence. And that contractors can also be subject to disciplinary proceedings as set forth in the controlling statute, which is 489-129. Things like being placed on probation or reprimand of the license, revoke, suspend, or deny the issuance or renewal of the certificate of registration, requiring financial restitution, having to pay for the department's investigation of these claims. It's all, nasty repercussions that, again, this is one of those times where, because the law is new, we want to just fly under the radar as much as possible.
And part of it is controlling what you can control, right? If you have an overzealous DFS agent who hasn't met a quota or has been given certain mandates from their manager, there's virtually nothing you can do to control that. But you can control your Instagram posts, right? That much you can control. You can't control your door hanging. You can't control your ability to generate an estimate. So a lot of this is, let's not get so caught up in everything in the possible world that can happen. There's 6 major points that you have to comply with. Comply with those points, be compliant, lay low early, see how the case law develops on these issues, and kind of go from there. I mean, it's just not the time to stray too much early into a new law in 7/1. We're coming off the heels of a major reform in 2019 in the state of Florida, which was assignment of benefit reform. And that kind of played out. And to a certain extent, that didn't have as much teeth, right? We didn't know exactly what was going to happen, but it almost didn't impact the insurance industry to, the property damage, the consumer side, right? It wasn't as devastating as we thought. So let's let this bill, make sure your roofing company is able to be compliant with it, and let's see where it goes from there. Our take on it is don't be the rebel. Or you could be. Some people, I was talking to someone today, someone who moved to Florida, who came here from Alabama, and I said, hey, I don't know how close you want to get. And he says, I like to get close. Well, that's on him. That's on him.
Lots of business decisions. Risk tolerance is the game here, and I'd rather be on the low risk tolerance when it comes to governmental fines and penalties and things like that. So $10,000 a pop seems like maybe I'll change my language a little bit and learn how to sell better than than that. So.
And this is not gloom and doom. There's a range of penalties,
yeah,
right? And it's based on a bunch of things, but that is a penalty. And again, particularly for your written materials, I can't emphasize it enough. I would have thought that some of these roofers that I had quoted a little bit earlier would have already began to change their policies. Like, there's no reason why would you post something that's non-compliant 2 days before the law changes. I would have thought they would have generated new material that is compliant. So, that would be my advice is, live and accept a new world.
Yeah, we went through I think it was the week the bill was signed. I don't even know if the bill was signed, but it was going to the governor's desk, and it was getting signed. And so we had our team go through all of in our marketing agency. We had all of our Florida clients. They went through every page on the website, every Facebook ad, every Google ad, everything that we had, all the language to make sure that, and we of course erred on the side of caution. And then if there was anything that we weren't sure about, we brought it to the contractor and said, make a business decision.
Okay.
Really.
And that's also going to be a great service to your contract.
Yeah,
because they trust in you.
You got to get ahead of this type of stuff. You really do. And that's why we wanted to put this together and get this out, as soon as possible, with the law going into effect July 3rd or July 1st. Like, it's here. It's here. So, it's time to start implementing this and getting going. What other is there anything else that contractors should look out for or think about as these changes are being implemented?
Well, so really the rest of the sections in SB 76 deal with, homeowners' deadlines to file claims. That would be 2 years on a regular claim, 3 years on a supplement. And the rest of it really just deals with attorneys. It's provided a lot of extra hoops for property damage attorneys to jump through before filing a suit on an underpaid or denied claim. And so, what we tell all of our roofers and all of our PAs that we work with is just to make sure that the attorneys that you're working with are on the ball. Way too often we see attorneys who take months to file claims that are ripe and ready to go and are just not doing it. And so when you have SB 76, which gives insurance companies additional opportunities to change coverage decisions or to force an appraisal or a mediation or just delay the process, we have to keep in mind that this affects homeowners directly. It affects our roofers. It affects everyone but the insurance companies in a potentially negative way. And so really what it boils down to is just making sure that the attorneys that you're working with and that your homeowners are working with understand the law fully, are ready to go and jump into action starting on Thursday and are on the ball.
Yeah, this is something for contractors to add to their sales presentation also, or post inspection part of the process is, hey, this is, if this claim gets denied, here are the things that you need to know. Here are the rule changes that were made with SB 76. So make sure that when you're going, if you're hiring an attorney to do this work, here's a place where a contractor can educate the homeowner on what they should look for in the attorney that they're hiring.
Great point. And we're not the only property damage firm in the state of Florida. There's a ton of firms, and a lot of them have been doing these presentations. And the one thing that I think that, I'm proud of at our firm is that we give pretty straightforward an interpretation of the law. And I do want to differentiate. There are some firms saying, hey, one way to circumnavigate this law is by sending every claim to us, right? Mm-hmm. And so, and it seems funny. It seems funny, but I do want to say that it's actually, that's not what we want, right? That's a lot of work adjusting claims, and we believe that the insurance company should be given the opportunity to do the right thing. So we don't want to jump into a claim too early. But as a technical point, I think they're right, because guess who's not regulated by these laws? Are attorneys. And so if you wanted to go back to the insurance crutch, you can show up and, somehow, without violating the Florida bar solicitation rules, get an attorney involved early, and there wouldn't be that regulation on them. Our motto has always been, if you can get paid as a contractor, you don't need us, right? So we take a slightly different approach. We'll get involved anytime people want us to get involved. But I think, there's a good percent of times that the carriers do the right thing without attorneys getting involved, right? So we want, you as you're setting expectations, you're letting them know, hey, there's a chance that they're going to do the right thing and everything's going to work out. But there's a chance that there's not. And in that case, there may need to be an escalation or additional work done on your file, and you can set those appropriate expectations.
Yeah, that's great. And that going through the process now, you have there's the really what we talked about was there's two primary relevant sections. First, dealing with solicitation. Second, with deadlines for homeowners. The third isn't as relevant, but you touched on that, like how it impacts attorneys and dealing with the claims process there. What, I know Florida is a unique state in a lot of ways, but with our audience being national, do you feel that there's any implications that this is something that kind of becomes something that is sought after by the insurance companies nationally? Or, I see Patrick is just smiling there. The attorneys might not be, will be very, probably, you guys, attorneys are very good at their language, Patrick. I don't know if you're as good at your language as Winston and Sharon are here. But what do we see? Like, can this type of legislation, start to roll out nationwide and really impact the insurance restoration industry nationally, instead of just, being focused in Florida there?
It can and it will, unless contractors get together and actually decide that they're going to have a voice. In the state of Florida, you've got 200 lobbyists that represent the insurance companies in Tallahassee. I'm sure, and then you have 3 that are representing contractors and homeowners. I'm sure that number is very similar in many states. Contractors have to understand that these companies are putting millions and millions of dollars behind changing these laws in their favor. And they're doing a very, very good job of it. And the reason is because contractors are busy battling each other instead of battling, honestly, in my opinion, bad legislation. Now, every time in the state of Florida, there's a new enemy. In 2013, it was sinkholes. 2019, it was AOBs. Now we see it being in those pesky door-to-door salesmen and attorney fees. In 2 more years, it'll be a different story. What we have to begin doing is educating homeowners on a door-to-door and on a marketing level, on a grassroots level, to say, listen, we are the people that are looking out for you. These companies have done a great job. Jake from State Farm, you're in good hands, like a good neighbor. All of this crap that has been fed to homeowners for the past 10 years has done exactly that, because it's pinned homeowners at times against contractors. We need to be vigilant of that. We need to understand that that's the game that these individuals are playing. They are not telling their homeowners the truth. They are not calling them and telling them what this law really means. That is going to fall on good contractors across this country to step up and have a voice against big insurance, who is there for profits, not the people who pay their premiums. And we must be clear on that when we're educating homeowners.
Yeah, and I think that's a great point. And to follow up on that, Patrick talked about 3 things: sinkholes, AOB, and now roofer reform, right? And so if there's anything to be learned nationwide that we can learn from the state of Florida, is if you see these things coming down the pike, maybe be proactive instead of reactive, right? So what that means is some of these things that came through reform, roofers themselves were asking for, right? So instead of having your future dictated by the state legislature, why don't you be a little proactive and say, hey, here are some things that we could improve our industry, and be a little proactive and talk to local legislatures and say, here are some things we are willing to accept. And these are, we don't need an overreaching bill, but we do need modest and thoughtful reform. So if there's anything to learn from Florida, it's our side, the consumer side, has been reactive. Okay, we were reactive on the sinkhole, we were late, we were reactive on AOB, we were late, we were reactive, and all of these issues. And that's not to say everyone was reactive, but as a whole, we waited for there to be a push by the insurance lobby and then responded to that. You get out in front of there. If you're in another state and you even hear the winds of reforms, get out in front, think about what is acceptable, think about what is thoughtful and mindful legislation that could be helpful, not only to the industry, but to the consumers, and that's fair, so that you don't get really, really overreaching and really, really harmful legislation. So that's one of the big lessons that I think has come out of Florida in the past decade, is that if it's always going to be difficult being reactive. If you hear about potential legislative change, get together, like Patrick was saying, educate, create a campaign, and think about thoughtful, compromised legislation.
And you made another point too, that the narrative, that there's a narrative, these companies are really great at marketing, right? Insurance companies are really great at marketing. And the narrative around contractors is negative, right? You look on the local news and it's the ripoff of this old, this older couple that, someone took their money and this happened and that happened. So changing the narrative around the industry, which I think is happening a lot. There's a lot of great organizations out there that are working really hard to do this. There's a lot of great companies that are working really hard to do this. Joining your local associations, your national associations, being involved in the process, being involved in your industry, I think is another extremely important thing that you guys pointed out, because it's your business, right? You got to be involved before the legislation makes changes that impact your bottom line in a negative way. So anything else that you guys want to add, touch on before this gets enacted here on July 1st?
Yeah, nothing specific comes to mind. I'm sure you'll have our contact information in the links. I think we did a good job of kind of going over the major points. Everyone's going to have some very unique questions, right? And so we speak with roofers, several times a day. We had a call this morning at 10 a.m. and it was a fascinating question. It said, well, isn't an insurance policy, can't they not change a homeowner's rights during a policy period? I thought that was an incredible point. I thought that person was spot on. But guess what? That has nothing to do with a solicitation, right? That has nothing to do with, they're absolutely right. You can't change substantive rights during a policy period, but you can regulate the manner in which solicitation happens. So let's not think too big about this. And there's a lot of nuances that err on the side of caution. As a technical point, he was right. But guess what? Had he put a bad Instagram post, that's not going to save him a $10,000 fine. Yeah. Right? So you can argue these nuanced legal points, until you're blue in the face. At the end of the day, do your best to comply, and run your business and do a good job for your homeowners and continue to grow.
Well, that's great. Thanks, Winston and Sharon from Taitt Law, and we'll have the links to their company in the description if you want to get a hold of them. Patrick, good seeing you again, man.
Good seeing you, brother, as always.
Collar Media Group is the new business.
Yeah.
Getting contractors' social media right.
Hey, just creating content for people, man, making them engaging, right, making them relevant. And I can't do what you do, Jim. Obviously, you're the professional when it comes to using that content to optimize it the best for the contractor. But in order to optimize content, it's got to be good to begin with. I mean, you got to have something good to market. People would rather, if you got great engaging video, it makes your job that much easier. So that's what I'm doing over there, man.
Awesome, man. And we'll have Patrick's info in the bio too. Check him out. If you guys need any help with this, reach out to them, reach out to us. This has been another episode of the Roofing Success Podcast. If you would like to generate more sales through your digital marketing efforts, please visit roofermarketers.com and get a copy of the book, Internet Marketing for Roofing Contractors, How to Triple Your Sales and Turn Your Roofing Website into an Online Lead Generation Machine. Also, check the training section of the website for guides on everything from running effective pay-per-click ads to how to properly set up your Google My Business listing. This has been another episode of the Roofing Success Podcast. Thanks for listening.